Okay, good afternoon, good morning, good evening, whatever time it is where you are, to you, ladies and gentlemen. Now we're gonna go over chapter two from contemporary criminal law. Of course, my outline and my class stuff is from the second edition, but I've cross referenced all the editions, all the law is relevant. I'm teaching the right stuff. This is just where I prefer to organize myself with that book. So now we're going to talk about chapter two. Chapter two is about constitutional limitations. If you remember chapter one, I talked about the Constitution of the United States being the overarching law. It is a law that governs laws under it. So in this chapter, we're going to talk about constitutional limitations of criminal laws. So when there's a lawmaking body, a legislature that makes a law for society to govern itself, even that law that's made by the legislature is subject to being reviewed, and it has to also be constitutional. So just because a law is made by the powerful government, the Senate has gotten together and decided this is illegal, this isn't illegal, or your local city council has gotten together and they now have created an ordinance which governs the speed limits or NORDS ordinances. Those are also subject to constitutional limitations. That means they also have to meet constitutional muster or survive the constitutionality test. So even laws themselves are not impermeable. So meaning that they're not. So they also have a test. So it's not just your actions as a person that have to fall in accords to criminal law, but criminal law itself has to fall in line and be constitutional. So that's what we're talking about in this chapter. We're focusing on how laws are written, and whether or not the way they're written, the way they're written, whether or not based upon the way they're written, whether or not they're constitutional. So as an introduction, the United States is a constitutional democracy with limited powers. Um, Constitutional democracy. It is a system of government based on a constitution that limits the powers of government. And with democracy, it also gives people the power to vote, and it's what we call the power of majority. So majority rules in a democracy. Um, the authority of the state and federal governments to enact criminal statutes is limited by various constitutional provisions. So the Constitution of the United States says, yes, states, the federal government and state and local governments, you guys are allowed, not even allowed, it's essentially your duty to create laws that govern people in your jurisdictions, but even those laws have to meet or be able to jump the hurdles of the Constitution. So because the federal Constitution itself is the supreme law of the land. Now, first, we're going to talk about the rule of legality. An individual may not be criminally punished for an act that was not clearly condemned in a statute prior to the time that the individual committed the act. So if I commit an act and on Monday, and on Monday the act is legal, then on Tuesday it becomes illegal. I can't be punished because, of course, at the time when I committed the act, the act was legal. And it also is going to take us into bills of attainder and ex post facto laws, which we'll talk about. So in other words, what that means to be quick, is there's no crime without law and no punishment without law. So what that means is the law has to be illegal. So that means if it's legal for me to do, or it's not marked as being illegal, and I do it, you can't say it's illegal. You can't create law on the fly. It has to be already be created, and I already had to be illegal at the time I did it for you to be able to punish me. Then we're going to talk about bills of attainder. Bills of attainder, and this is some common law stuff that came over from England. This is one of the things that the American colonists did not like. So when we talk about the let's go to the Bill of Rights. When they created the Constitution, if you want to know the things that the British government was doing from overseas to really make the American colonists mad, look at the Bill of Rights. That is essentially a list of what you did to us that we're not going to tolerate here. So the First Amendment, that means we get to say what we want to say, and the government, there's no king saying, "Oh, we're gonna persecute you because you have an opinion that's different from everyone else's," or we don't like your opinion, so we're now going to put you in jail for saying what's on your mind. So that's where the First Amendment came from, because that's how the King of England was. You couldn't speak badly about the king. So when we had this new government, we definitely didn't want a king. So we established a democracy based upon the Constitution, and in that Constitution we had amendments that said these are things. These are the very important things that we want to govern our society, and the things we're not going to have. First and foremost, First Amendment, the right to bear arms. Second Amendment, of course. Then we skip to the Fourth Amendment, and so on. But if you want to know what the list of grievances was, or some of the things that Great Britain was doing to really piss off or peeve the American colonials, look at the Bill of Rights. So one of the things that came over from Great Britain and that was on colonial soil was what we call bills of attainder. A bill of attainder is a legislative act that punishes an individual or a group of persons without the benefit of trial. So in other words, you're punished and you don't get the due process of coming to trial and actually being found guilty before your peers. It's just because it happened, we're just going to punish you as a government. We're not going to give you the right to a trial. Of course, that is a no-no in colonial. I mean, that's a no-no now in American society, but in British law, it wasn't. So that's the Bill of Attainder. The constitutional prohibition of bills of attainder was intended to safeguard Americans from the type of arbitrary punishments that the English Parliament directed against opponents of the crown. A bill of attainder is not limited to criminal punishment and may involve any disadvantage imposed to an individual, whether it's taking property without giving you due process rights, whether it's, pretty much, it's either a criminal interest or a property interest. So anything that takes something away from you or bridges your rights without you having to getting to go to trial and be heard on it is a bill of attainder. Now, the next thing that they did that kind of peed Americans off was what we call ex post facto laws. I remember before when we talked about the rule of legality, for you to be arrested and charged and punished for something, it must be illegal on the books. In other words, we must, the law must say, it must be written out in law that it's illegal. You can't just create what's legal and illegal on the fly because you don't like what someone's doing now. I don't like that, so you're going to jail. Now, if before that person did that, you clearly noted in the statute or in the law that conduct is illegal and they did it, then you're cool. So that kind of leads me into the ex post facto thing. Laws subjecting people to punishment for things which, when they were done, were not against the law. What's that mean? I'll go back to my hypothetical. If on Monday I commit an act that is perfectly legal, and then on Wednesday the government decides that act, the actions I took are now illegal, they can't now come back and punish me retroactively for what I did before the action was illegal. That's what that means. So you can't. So an ex post facto law is a law that's trying to retroactively punish or aggravate a punishment. So we'll talk about it in another way. Let's say the act I committed on Monday it was illegal, but it was just a misdemeanor. But on Wednesday, the government gets together and they create a law that says now that same act that was a misdemeanor, now from here on out, it is a felony. It's punished harsher. They also can't come back and now make me a felon or punish me as a felon for what I did before that law became a felony. So you see what it means. Now, that's an ex post facto law. Every law that makes an action done before the passing of the law and was innocent when done criminal and punishes such action. Every law that aggravates a crime, as I just said, or makes it greater than it was when committed. Also, every law that changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed. Every law that alters the legal rules of evidence and receives less or different testimony than the law required at the time of the commission of the offense in order to convict the offender. So what it means, they can't retroactively make it worse on someone that's accused of committing a crime or the defendant. Now, on the flip side, let's say on Monday I commit an act that is illegal and I am arrested for it. But then on Wednesday, the government overturns the statute and says, "Nah, we're going to let this be legal now." Now they can retroactively take my crime away or not punish me or exonerate me. So that's not ex post facto. If it's making something that's done in the past, if it's lessening the punishment or essentially legalizing what I did in the past, and dismissing it or expunging it off my record because now it's legal, then that's not ex post facto. So it's only ex post facto if it's trying to retroactively make something that's already been done worse. Either make it criminal when it wasn't criminal before, or graduated from one level of crime to another level of crime, or take something away or change the law that makes it worse. So that's ex post facto. Ex post facto is always retroactively trying to make something worse. But if they're retroactively trying to mitigate or make it better, or let's say erase it or dismiss it, then that is not unconstitutional. So you can retroactively do that. And that's another thing about the Constitution. The Constitution is not, especially the first 10 amendments, the Bill of Rights. The Bill of Rights pretty much protects people that are charged against the government. So it's essentially, so like I said, the Bill of Rights doesn't really apply to victims of crime. The Fourth Amendment doesn't apply to victims of crime. It applies to people who are charged with committing a crime. Same thing with the Sixth Amendment. And the Fifth Amendment. So those things are. This is all making sure that people who are charged with violating some type of law of the government are going to be treated fairly. So you have the weight of the entire government against you. We have to make sure the government does things fairly. So now, the ex post facto law prohibition is based on familiar interest in providing individuals with notice of criminal conduct and protecting individuals against retroactive statutes. When the government refuses after the fact to play by its own rules, altering them in a way that is advantageous only to the state to facilitate an easier conviction. Legislatures are free to retroactively assist, as I said before, defendants by reducing the punishment to a criminal act. Then there's a case in the book, Stogner v. California, where the Supreme Court ruled that a California law authorizing the prosecution of allegations of child abuse that previously were barred by statute of limitations constituted a prohibited ex post facto law. So we're gonna every now again I'm gonna mention the case and the ruling from a case. So that case was in the book, Stogner v. California. Now, so we've gotten past that point. So that's the first level of the don'ts. We call that do's and don'ts. The constitutional don'ts. Where you can't have a bill of attainder, and they can't create a law that's essentially a bill of attainder, and the government can't create a law. The state or federal government cannot create a law that is essentially a ex post facto law. And then of course the law there's the rule of legality that says they can't just arrest you for something that's not on the books and is legal and say it's illegal without it. So in other words, in order for you to be brought before the court and charged with the crime, it must be a crime. So that's the first level. Now let's move on to something we call statutory clarity. So let's say now we do have a law that's written. When we talk about statutory clarity, we're talking about how well a criminal statute or a law is written. In other words, this is now the framework for how laws are supposed to be written. So a law is not written very well if, as the people, we read the law and we still can't tell what's wrong and right in reading the law. So in other words, what conduct is illegal? So that's what we talk. So a law can't be vague, right? That means a law can't say, let's say something like, it's illegal to drive too fast. Okay, that's cool. We understand that we don't want to drive too fast, but what is too fast? I have a speedometer in my car, so if it says don't drive too fast, that is vague because it's not telling me exactly what is legal and illegal, and it's not giving me a clear red line or bright line standard. But a law that says it's illegal to drive more than 35 miles per hour in this zone, that is clarity. That's statutory clarity. That means I can't drive and be driving at a pace of more than 35 miles per hour in this area. So that's why we have very clearly written speed limit signs. It doesn't just say don't drive too fast, because that would be vague, and we're going to talk about that. So clarity. The Fifth and Fourth Amendments prohibit depriving individuals of life, liberty, and property without due process of law. So when we talk about due process of law, that's not just your right to be heard, but it's also your right to be put on notice so that you can defend yourself. It requires notice of criminal conduct. So in other words, the laws must be clear enough to tell me what the illegal conduct is, so I'll know not to do it. If the law is unclear, then how can I be punished? Even in reading the law, how would I know what's illegal and what isn't illegal? So that's why it has to be clear. That's why we have to have clarity. It also requires that the police, prosecutors, judges, and jurors are provided with a reasonably clear statement of prohibited behavior. So if we're going into court, and the court system has control of you, the court system has to have clear standards to determine your guilt or innocence. This ensures clarity in the criminal statutes. What's about clarity? Also, when statutes are not clear, it allows for the lines and I guess the roles of law of certain parts of the criminal justice system to be blurred. So law enforcement, their job is essentially to enforce the law as it's written. If someone's out of line, now we enforce it, we arrest you, we serve you with papers, and you have to come to the court, and then it's the court's job to determine your guilt or innocence. We just stop if we see something that's wrong based upon the statute. We stop you, put you on notice, give you papers, or arrest you and take you to jail, give you papers, and the rest of it's up to the court. The job of law enforcement is not to determine guilt or innocence or guess and figure out what the law is or make the law right there as they're enforcing the law. So when a statute or a law is unclear, it gives law enforcement discretion to now create the illegality right there. So that's the danger of having a law that's very badly or unclearly written, is it gives unfettered discretion to law enforcement. And law enforcement is a very powerful part of the criminal justice system, because that's how everyone gets into the criminal justice system. Literally, you don't become a defendant until you're arrested, right? So law enforcement encounters you, and that's what brings you to the criminal justice system. If they're doing that and there's no clarity in what they do, that means it's essentially arbitrary. There's no clear, bright line test for what's legal and what's illegal. So now the law enforcement officers are just pretty much arresting people and charging people based upon their own personal preferences. When we'll get to this when we talk about vagueness, but let's say if there's a law that's written that says, what was I talking about before? If it says don't drive too fast, it's illegal to drive too fast. What is too fast? So what happens is if there's no clear bright line test for what a speed limit is, and it just says don't drive too fast, now you have law enforcement out here without bright line test, and they can just stop who they want to. A person can be driving 5 miles per hour, and that cop based upon what they think and say, oh, that's way too fast. You need to be driving 1 mile per hour. So now you got this person arrested or charged with something. And then that same cop or a different cop could say, well, I think 25 miles per hour is too fast. So you see there are differing standards. So we're now bringing people into the court system not based on bright line test. So it gives officers discretion. And anytime you give law enforcement discretion, now you have a situation where bias, including racial bias, can now creep in. So now that officer who may not like white people, let's say may not like black people, is now pulling over everyone that's black because he was driving too fast. Not that he was driving over a definite defined statutory limit, but he was driving too fast, in my opinion. So we want to take away that law enforcement discretion. And we want to have bright line tests. That way it's more likely to be fair and equal for everybody. So, let me see. All right, as I said before, okay, we talked about clearly. Okay, so now we're going to move into what we call definite standards for law enforcement. Laws must be written and designed in a manner that protects citizens from unfettered discretion on the part of law enforcement. I just explained that. Cops shouldn't have any room for subjective or arbitrary decision making when charging a person with a crime. To let a policeman's command become equivalent to a criminal statute comes dangerously near to making our government one of men rather than laws. The Fourth Amendment keeps cops from kicking down doors without warrants, right? The lack of standards presents a danger that a law will be applied in a discriminatory fashion against minorities and the poor. A lack of standards also may lead to the arrest of individuals who are exercising their constitutionally protected rights. We all have a right to be different without being harassed by the consensus or law enforcement. Now, we're going to move into void for vagueness. So we talk about, what is a vague law? Judges appreciate the difficulty of clearly drafting statutes and typically limit the application of the void for vagueness doctrine to cases in which the constitutionally protected rights and liberties of people to meet, greet, congregate in groups, move about, and express themselves are threatened. So that's another thing about the Constitution. Also created the roles of government, and it created the three basic branches of government. You have the judicial, the executive, and the legislative. So the legislative's job is essentially to make laws. The executive branch's job is to take those laws that are made and now enforce them, and delegate responsibility to make sure that the laws are carried out and enforced. That's what the president does. He's essentially the commander-in-chief and the enforcer of laws in America. Then, last but not least, there's the judiciary. The judiciary's job is to now look at both the actions of the executive or presidential or executive branch, whether it be state or local executive branch, and look at the laws that are being made by the legislative branch to determine constitutionality. So that's what we call judicial review and judicial interpretation. It's their job to look at laws and make them clear. So let's say a law may be written vaguely, like that law that says you can't drive too fast. You can't travel too fast on the street. That law is vague. So what happens is the person gets arrested for it, and they challenge it by appealing. It goes to the Supreme Court, and then it's the judiciary's job to clear that law up, to say, okay, that law is vague. The law needs to say this. We're going to send it back and need to change that law. So legislature, the law is unconstitutional because it's vague, and then now the legislature has to come out with bright line tests and clear standards for what's legal and illegal, and that's how laws get changed. So that's the process. That's the lawmaking and constitutional kind of wheel or process. So we're going to look at State of Montana v. Stanko, and this is this case. You're going to realize where I got this hypothetical from. It was pretty much from this case. An excessive speed statute was deemed void for vagueness on its face because it failed to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden. And the court says a person operating or driving a vehicle on a public highway shall drive the vehicle in a careful and prudent manner and at a rate of speed no greater than is reasonable and proper under the conditions existing at the point of operation, taking into account traffic conditions. And so that was how the law was written. So the law doesn't get, it just says you can't drive at an excessive speed given the conditions. But it doesn't tell us what the excessive speed is. The person must operate the vehicle so as not to unduly and unreasonably endanger others. So the law had a good purpose. We want the streets to be safe, but the law, as written in this Montana statute, has to be clear. It can't, we know why they want us to slow down and not drive at excessive speed. That's cool. We understand that. It's not the purpose of the law that's being challenged. It's the writing of the law. In other words, that the whether the law is clearly written. So Stanko was driving 85 miles per hour on a 2-lane highway with no posted speed limit. Stanko was convicted at trial and he appealed. The officer's opinion was that Stanko's driving was unreasonable, but he offered no opinion regarding what reasonable speed was. So it's not even up to the officer's opinion. It shouldn't be up to an officer's opinion. The law should say what it's supposed to be. So the court said that no person should be required to speculate as to whether his contemplated course of action may be subject to criminal penalties. As a speed limit, the statute does not meet these requirements of due process and is void for vagueness. So the trial court, the verdict was reversed, and of course it was sent back down to the trial courts. And of course, essentially what they were saying was the way the ordinance or the statute was written was void for vagueness, so it actually sent it back to the maker of the law, the legislature, to rewrite it and to put clear standards in it. So that's what we call void for vagueness. So notice, so laws, when they're clearly written, they give us notice of what's wrong and what's right. In other words, what I'm allowed to do and what I'm not allowed to do, and standards. And it also limits the unfettered discretion of law enforcement officers. So when we have these standards, instead of law enforcement officers going based upon what their opinion is, and that's not what we want, we have a law that sets clear standards. And in setting clear standards, it also puts us on notice. So we'll be less likely to commit an offense if we know what the illegal offense is. So when we have posted speed limit signs, I can look at my speedometer where I'm driving and say, oh, it's 35 here, so I need to slow down and go under 35 miles per hour. So that's the void for vagueness and clarity portion. Now let's talk about the equal protection portion of the constitutional limitations. 14th Amendment, no state shall deprive any person of life, liberty, or property without due process of law or deny any person equal protection of the law. 5th Amendment imposes the same or obligation to ensure the equal protection of the law on the federal government. So, of course, the 5th Amendment came first, and then the 14th Amendment essentially says the 5th Amendment equal protection clause also applies to the states. So, 3 levels of analysis. So when we look, now we're going to look at laws that are different. So the reason we're bringing up equal protection is there's some laws that treat people differently than other people. What I mean by that is there's some laws that make it illegal to be within a class of persons, not illegal, but or they penalize a person for being within a class of persons. So one of those laws that most of you guys are college students, so the vast majority of you are either between 18 and 24 years old. Matter of fact, a lot of you are probably less than 21 years old. So if you're less than 21 years old, and specifically in North Carolina, we know one thing you can't do. You can't possess or walk into a store and buy any alcoholic beverage. So that is an example of a law that is classifying you or treating you differently based upon some characteristic. So it's classifying you by putting you in a class of people that are going to be treated differently, or a class of people that can't do something that everyone else can do. So in North Carolina, if you're less than 21 years old, you can't purchase or possess or consume alcoholic beverage, right? So now we're going to look into laws that differentiate or classify people based on a number of characteristics, and we're going to determine whether or not those laws, as they're written, are constitutional. So so this is now what we call the equal protection analysis. So we're going to look at laws. So the first question you ask yourself is whether or not, if you're going to apply an equal protection analysis to figure out whether a law is constitutional, the first thing you need to ask yourself is whether or not the law even treats people differently. Does this law classify people or treat people differently or impose different sanctions on a person or any group of people based upon anything? Does it classify people first? Then if it does, what is the basis for the classification? So the 21-year-old, the less than 21 law, an alcohol law, that is a law that classifies people or puts people in a class and treats them differently based upon a characteristic. Now we ask the second question: what is the characteristic upon which it bases the classification on? And in this situation, it bases the classification on age. So everyone that's not 20, that's less than 21 is now put in this classification or this group, and they're prohibited from doing something. So we have a law that classifies or treats people differently, and then then we have to ask what is the basis for that different treatment. And the basis in this situation is age. So if we were to create a flow chart, that's how the equal protection flow chart goes. Does the law classify, treat people different? And what is the basis? So we go back to the law from the Stanko case. That law didn't classify people or treat people different because of who they were. That law just said you can't speed, right? And that's it. It didn't say black people can't speed or people less than 21 can't speed. It was just a regular law that applied to your actions and not who you were. So when we talk, when we try to test the constitutionality of laws based upon the equal protection, first we have to figure out whether or not we're even going to apply an equal protection analysis to determine the constitutionality of the law. And figuring that out and answering that question, like I said, you ask the first question: does this law classify people or treat people differently? If it does, what is the basis upon which it treats people differently? And that second question is very important because that's gonna determine what standard or test we apply to the different classifying categories. So we'll talk about the test first. You have 3 levels of scrutiny. When you're testing the constitutionality of a law that treats people different. So you ask that first question: does it treat people different? Yes. If the answer to that is yes, then you move on to another question. That next question is: on what basis does it treat people differently? So, depending on what that basis is, you're going to apply one of 3 standards to determine the constitutionality of that law the way it's written. So the first test is what we call the rational basis test, or I call it RBT. The rational basis test applies to laws that classify people based upon age or disability. And the rational basis test, the way it reads is, it says a law that classifies is presumed to be constitutional or valid so long as the law is rationally related to a legitimate and permissible government interest. So it's a very low standard. In other words, we asked the first question: does this law classify? Yes. What is the basis? The basis is age. So a law that says if you're less than 21, you can't possess, buy, or consume alcohol, that is a law that classifies based on age. So now because it classifies based upon age, then we know we're going to apply the rational basis test. So in the rational basis test, there is a presumption that the law is valid. So what we're saying is the law is valid, and the person is challenging the law. That person is 20 years old and wants to drink. They get arrested for possession or charged with possession of alcohol. And they say, well, why can't I possess alcohol? I want to challenge the law. I believe it's unconstitutional that you're treating people differently based upon their age. So when they challenge the constitutionality, the court is going to apply the rational basis test. And it's going to say, well, because of the classification and because of the test because this classification requires the rational basis test, the law automatically walks in the door as constitutional. So when the court is reviewing this law that classifies people based on race or some type of physical disability, when it hits the desk of the judge or the judges are looking at it and they're saying, well, the law is automatic. It comes in here constitutional. So now it's up to the person that's challenging the law, not the maker of the law or the legislature or the government. It's up to the person that's saying, hey, I think this is unconstitutional as a person that's been charged with possessing alcohol, being less than 21. That person has the burden of showing us why. So you say it's unconstitutional. You have the burden of telling us why. So there is a presumption of validity, and the burden of proving its invalidity rests upon the challenger of the law. That's what I just said. So that person has to prove. So the law is deemed to be constitutionally valid, so long as it is rationally related to a legitimate and permissible government interest. So that person now has to show us why the law that classifies based on age is not rationally related to a permissible or legitimate government interest. So, what is the government interest in this situation? The government interest is in protection of people of society, making sure people are of a certain age before they partake in spirituous liquors and things that can intoxicate them. So there is legitimate interest in that. So we know there's legitimate interest, and the law itself is rationally related to it. So it's not like they said everyone can't drink. They said if you're under a certain age, you can't drink. So in other words, the law itself, there's a rational basis between the prohibition and the interest that the law is trying to protect. So that's the rational basis test. That's the first level, the lowest level of scrutiny. And the rational basis test only applies to laws that differentiate or classify based upon age or disability. So if there's a law that says, hey, you're handicapped, you can't do, you're prohibited from doing this, or you're too short to ride this ride, not that would be a law, but that's what we're going to apply, the rational basis test. Now to the next level of scrutiny. This is called intermediate scrutiny. Now I said there are 3 levels, and this is intermediate, so it's in the middle. Intermediate scrutiny. This applies. Remember, we asked the 2 questions: does the law classify, and if it does classify, differentiate people? What is the basis of differentiation? If the law differentiates people based upon gender, sexual orientation, illegitimacy, meaning your birth, whether you know your parents or whatever, or that's rights being given to someone based upon parentage, and certain aspects of freedom of speech, then we're going to apply the intermediate scrutiny test. So if it's a law, like let's say the HB2 law back from a few years back, that prohibited people who were born had a certain birth gender that changed their gender from now using the bathroom of the changed gender. So if I was born a man, but I'm now considering myself a woman, I can't use the restroom in the women's restroom because I was born a man. So that is a law that treated people differently based upon sex. So gender, not necessarily sexual orientation, because there's a difference between orientation and gender. So a lot of stuff we talk about when people have what they call gender, when they recognize themselves as being a certain gender, that's gender recognition. That's not sexual orientation. That's a difference. So this person is saying, I was born a man, but I consider myself a woman. So I want to go to the women's bathroom. This House bill that was created by the North Carolina Senate prohibited that. It said you have to go to the restroom of the gender that you were born as. So if you were born a man, you're a man. You got to go to, in other words, it's illegal for you to intrude into the other bathroom, because now you're endangering women and what if a little girl's in there, stuff like that. So that was the basis. I think it was corny, but that was the basis. So now that you've looked at the law, you've seen that the law differentiates or classifies people based on the characteristic, and then you've determined that the characteristic is gender. What standard do we apply to determine the constitutionality of this law? That standard is the intermediate scrutiny test. So, and the intermediate scrutiny test reads: a classification must be shown to be substantially related to an important government objective in order to meet the equal protection analysis and be deemed constitutional. So it applies. So the burden of proving that the law is constitutional has now shifted to the proponent or the maker of the law. So once a person gets arrested or gets charged with violation of House Bill 2, and then now they're challenging the law. They take it to court and say, "Well, I was found guilty. Now I want to challenge. Now I want to appeal and challenge the constitutionality of this law." So the law comes onto my desk as being unconstitutional on its face. So the law that and just because the law differentiates people and it differentiates them based upon gender or sexual orientation, legitimacy, and there's certain aspects of freedom of speech that we'll hit on, that law is automatically deemed to be unconstitutional. So it's unconstitutional, but there is it's what we call a rebuttable presumption. So it's presumed constitutional. It's presumed unconstitutional, but it can be proven to be constitutional by the person that's the proponent of the law. So now the maker of the law, or the government, now has the burden of showing us why it should be constitutional and why we should find it to be constitutional. So you see how the burden shifts. When we have under that lower level intermediate rational basis test that applies to a different classification, it's presumed to be constitutional, and the person challenging the law has the burden of proving that it's unconstitutional. Now, as we move to a different classification, we have a stronger test. So even the words change, right? In the rational basis test, it was just rational relation to a permissible government interest. Now we have stronger words, right? We have words like it must be substantially related to an important, not just permissible or allowed, but it has to be substantial, which is a different word, which is definitely different words than rationally, but it has to be substantially related to, and now instead of it being permissible, now that word is now changed to important. So it has to be substantially related to an important government interest. So you see how it gets stronger, it gets muscles. So like I said, now the burden of proving that the law is actually constitutional has shifted. So there's a presumption of unconstitutionality, and now the burden is shifted to the proponent of the law, or the government, or the people that created the law, or the ordinance, to now tell us why we should reverse and say that we should find it to be constitutional. So it comes in unconstitutional, but it can be proven otherwise. We'll go to a case, the case of Wright versus South Carolina. A man was convicted of domestic violence law violation, and he challenged a portion of the law that aggravated the offense if the offense was committed by a man and the victim was a woman. The Supreme Court applied intermediate scrutiny, and they upheld the law based upon the rationale that the difference in gender aggravator was legitimately based upon real physiological size and strength differences of men and women, such that does not violate equal protection. So, in other words, the law that differentiated or treated men harshly for assaulting females was substantially related to the furtherance of an important government interest, and the important government interest was protecting a class of people that were physiologically weaker than another class of people. In other words, we're not going to let these people that are physiologically stronger men beat up on women and just be treated like they're fighting men. We're going to now make it more of a punishment because they're essentially attacking a weaker class of people. So the court said that law is they actually found the law to be constitutional. So the guy had a beef, he was saying, well, why you treat me differently because I'm a man? I'm going to challenge the constitutionality He said, why are you treating me differently because I'm a man and I'm accused of assaulting a woman? Like, I think it should be fair. So I'm going to challenge the constitutionality of the law. And challenging the constitutionality, the statute or the law came in unconstitutional, and then the government had to tell why it should be constitutional by explaining that the law itself and the means of the law and the prohibition of the law, or the punishment of the law, the way it punished, was substantially related, and there was an important government interest, and an important government interest was protecting a weaker group of people, women, against people that are physiologically stronger than them. So the law deemed that South Carolina statute was constitutional, and now most states have an assault on female statute where where it is. So you have regular assault, like if a person hits a person, a man hits a man, it's assault, right? But if that man is above a certain age and he assaults a female, then it's not the same as that lower level assault. It's now graduated and it's punished harsher because it's now a grown man assaulting a female. So that aggravation in punishment is now is deemed constitutional everywhere. So every state has some type of some version of an assault on female statute. North Carolina has one too. So that's the equal protection analysis applied to using the intermediate scrutiny test on classifications based on gender, sexuality, illegitimacy, and then we'll talk later about certain types of freedom of speech. Now, the third and final, strict scrutiny. So we ask ourselves the first question: does the law classify, and what is the basis of the classification? If the basis of the classification is based upon race, religion, or nationality, we're now going to apply another level of scrutiny. So we're going to apply strict scrutiny. So if you have a law that now says it's illegal, it's essentially illegal for black people to be outside after 6 p.m. That law on its face differentiates or classifies people based on a characteristic, and that characteristic is race. We're now going to, is a different standard. Just like intermediate scrutiny, that law walks into the courtroom on its face, and it is unconstitutional the moment it comes in. And once again, the burden is on the government itself that made the law to now show us why it is constitutional and why it should be deemed constitutional. So it comes into court constitutional on its face. But the burden is now on the government or the proponent or the lawmaker to show why it actually should be constitutional and not unconstitutional. So the strict scrutiny test, it applies to what we call the suspect classifications. That is race, nationality, religion, and alienage. These are all things that we call them suspect classifications because of the history of America, and not necessarily treating people fairly based upon race. That is America's birth defect, slavery and racism. So there's a stronger test. And how does the test read? What is the verbiage of the test? A classification must be shown to be narrowly tailored to advance a compelling government interest, and it must be the least restrictive alternative in advancing that interest. So you see how the words change from test to test. You go from rationally related to a legitimate and permissible government interest. Then you move up to intermediate scrutiny, where we say it must be substantially related to the furtherance of an important government interest. And now we have our third and highest level that applies to race and nationality classifications, and it says the law must be narrowly tailored and the least restrictive means of furthering a compelling. So compelling, you think about something that the government has to do or is moved to do because it's that serious. A compelling government interest. The suspect classification criteria. So I just read out to you the word. So the classification of the law itself, the law that classifies, must be shown to be narrowly tailored and the least restrictive means of furthering a compelling government interest. Those are the words that you use. but it applies to suspect classifications. Now we're going to talk about suspect classifications, and these suspect classifications are race, nationality, religion, and alienage. So the group is a suspect classification if the group has historically been discriminated against or have been subject to prejudice, hostility, and or stigma, perhaps due at least in part to stereotypes. They possess an unchangeable or what we call immutable and highly visible trait or characteristic. They are powerless to protect themselves via the political process. So that we call that. So that's what we call discrete and insular. So they're discrete and they're insular because they can't protect themselves. In other words, the greater weight of the system, they are a minority, and the greater weight of the system doesn't work in their favor. So when you hear us talk about discrete and insular minority, we're talking about people that have been discriminated throughout the history of this country. So we're mainly talking about black and brown people. This scrutiny test is so high because it's meant to protect discrete and insular minorities. The group's distinguishing characteristic does not inhibit it from contributing meaningfully to society. So if you think about it, there is an immutable characteristic. I can't scratch this brown, this melanin out of my body. I was born this way. It is who I am. So I can't change it. So that's what makes it a suspect classification. So now let's go to some cases where we now look at how the strict scrutiny is applied. So remember the two words. Remember the verbiage for each test. So let's say if you get a hypothetical on a exam or on a writing assignment, you have to, like I said, ask the question: does the law classify? If it does classify, what is the basis for the classification? If the classification is based on race or nationality or religion, then if it says like Jews can't hang out on the corner or something like that, then you say, well, because this classification is based on a suspect classification, then we're going to apply the strict scrutiny equal analysis standard or test. The strict scrutiny test says that the law is deemed to be unconstitutional unless it can be shown that the law is narrowly tailored and the least restrictive means of furthering a compelling government interest. And that's how your verbiage needs to sound. The first case, Loving versus Virginia. If anyone's ever heard, there've been several documentaries and a movie made about the Loving case out of Virginia. They were. I think they lived in like I think they were in Arlington, Virginia, or like in Emporia somewhere. Wherever it was, they were maybe an hour or two away from D.C. Because D.C. itself is not part of Virginia. But there was Virginia enacted a statute that banned interracial marriage, and an interracial couple was convicted of violating this law. So that's what we call an anti-miscegnation law. So a law that essentially made it illegal to intermarry with another race. So there was a couple, and actually they're called Loving. They were loving each other, but it was actually a white female whose his last name was Loving, and he got married. He grew up in a neighborhood where their neighborhood was kind of mixed. They had black people that had a farm, white people, and he fell in love with Mildred. And he married Mildred Loving. He married Mildred, and her last name was now Mildred Loving. I think it was Mildred Loving. I think it was Fred and Mildred Loving. I think I might have the first names wrong. But it was a white male that married a black female. And they happily married, had plenty of children. But then once the local authorities found out that they were married and cohabitating, then they got charged for violating this miscegnation law, this anti-miscegnation law. So now they were brought to court. Of course, they were convicted, and they challenged and as a part of their conviction, they were put on probation, and they were essentially banned from the state of Virginia. The only way they could come back and be in Virginia is they couldn't be married, or they definitely couldn't live together. I don't think the marriage was never annulled, but they definitely couldn't live together. So they almost had to sneak in. Now mind you, they had land in a whole big old house, and they ended up having I want to say they had at least 5 kids. So they were raising their family, but they couldn't even come back into Virginia where they lived, this rural town, and live together. They had to like put up appearances that they weren't together, they were apart. So they, of course, they weren't sentenced to jail time, but they were put on probation. That's probably because he was a white man. If it was the other way around, he wouldn't have gotten a trial. Probably would have been hung in a tree. But they challenged the law. They challenged the constitutionality of the law, and they appealed. In their appeal, the Supreme Court applied the strict scrutiny test. So they had to add the Supreme Court asked itself the question. It said, okay, this law on its face is unconstitutional. In order for it to be found constitutional, it must be deemed to be narrowly tailored and the least restrictive means of furthering a compelling government interest. So, in asking themselves that question, the court said this isn't a compelling interest at all. So, even if it is narrowly tailored and the only way or the least restrictive way of furthering this interest isn't compelling at all. There's nothing about the interest, this interest that the government is trying to protect that has anything to do with the furtherance of the government or protection of the government from something compelling. The court said there was no compelling interest in banning interracial marriage other than the discriminatory interest in furthering white supremacy. The Supreme Court overturned the conviction and found the statute to be unconstitutional. So the Lovings lived happily ever after, and I think they had a big enough family that at least a certain part of Virginia, a lot of them akin to the Lovings. I want to say it's not in Port. I can't remember the town. It was it's like south of Fredericksburg or so. It's in that area. But so during the time, and if you look at the documentary, during the time when they were going through the trial and the appeal, and the Supreme Court was hearing the case, they were living in D.C. So the closest place where they could be themselves was D.C. And because D.C. is federal, it's not under the state of Virginia, so they could live there. But they didn't feel comfortable there. That we have our own house and our own land. We're rural people. D.C. is a city. We shouldn't have to move to D.C. to be married. We should be able to be married in Virginia. That is the court applying the strict scrutiny test to that case. In that case, now we're going to move on to another case, Korematsu versus the United States. Now, Congress enacted a wartime, this is World War II law that applied a temporary curfew and living distance restriction from militarily classified areas upon Japanese immigrants or Japanese Americans. So if you study history, and that's another thing about cases, in law, these cases do not exist in a vacuum. There's something going on at the same time. There's some type of social thing going on or thing going on when these cases are heard, right? So during the Korematsu case, of course, if you know about World War II, we were attacked by Japan, and we entered the war. We entered World War II because the Empire of Japan attacked Pearl Harbor. They bombed Pearl Harbor, and that put us into the war. But when we got into the war, of course, at that point, there were millions upon millions of Japanese immigrants that lived in America all throughout. So President Franklin Roosevelt enacted a executive order that put a curfew and a living restriction on all Japanese immigrants and or Japanese descended people in America because and it also the living restriction meant they couldn't live within a certain radius of a militarily classified area. So in other words, if you live near one of those areas, they would move you and put you in an internment camp. And when I say internment camp, it sounds like what it sounds like. It was a concentration camp. Now, they weren't gassing people like the Germans were, but they were essentially moving these people. And it's called a concentration camp because it's a place where people are concentrated based upon some characteristic. So these Japanese people were put in this concentration camp or in several concentration camps all over America so they could be moved away from militarily classified areas. So in other words, they wanted to make sure that there weren't Japanese spies living and being able to infiltrate in militarily classified areas while we were at war with their country of origin. But the law was enacted through executive order. The Supreme Court applied the strict scrutiny test, and guess what? So remember, with the strict scrutiny test that we say is the law narrowly tailored and the least restrictive means of furthering a compelling government interest. So the Supreme Court said, well, it's narrowly. They agreed it was narrowly tailored or well written, um, the least restrictive means, and they said there was definitely a compelling interest in protecting our country during wartime against people that descend from the country of our direct enemy. We're not kicking them out. We're not killing them. We're just saying while we're at war, you can't live near these areas, and if you do live near these areas, we're going to enforce either going to move you out, or we're going to enforce a curfew to make sure you're not rolling around in the dark, spying on us and seeing what's going on while we're at war with your country of origin. So, surprisingly, the Supreme Court actually upheld the law, even though, remember, the law comes in and is unconstitutional as it's written. So the executive order was unconstitutional, but the court said, we're going to find that this law is constitutional because it's narrowly tailored and it's the least restrictive means of furthering this very compelling government interest in protecting our country from espionage what do you call it? Trying to think of the word now, and sabotage during time of war when we have a direct enemy, Japan. So it is a compelling government interest. So we're going to find that this executive order is constitutional. So the Supreme Court applied strict scrutiny and upheld this law under the rationale that the exclusion was not due to race or due to racism, but due to the fact that we were at war with Fred Korematsu's country of origin. The Supreme Court declared that the federal government did have a compelling interest in protecting the national security of the country during time of war. Now, you're going to learn in Supreme Court opinions, you have 9 justices, and all they need is 5-4 for it to be, for it to roll. And of course, I think it was 5-4 in this decision. But you can have what we call concurrent opinions. So those are the opinions, the written opinions of those that are with the majority of the court. And then you have what we call dissenting opinions or dissents. And that's when the losers or the people on the other side of the majority or the minority decide to explain why they didn't vote with the rest of them and why they think the case should have been seen their way. So in the dissenting opinion, it said that this exclusion goes over the very brink of the constitutional powers and it falls into the ugly abyss of racism. So even though the Korematsu case, they found it to be constitutional, that case has always been looked at with ridicule, in the future. It was like, Korematsu case, that was a bad time in American history. So that dissenting opinion ended up being kind of the stepping stone for why almost any law that differentiates people based upon race or nationality is just going to be unconstitutional. So for the most part, other than the Korematsu case, pretty much all of the cases that have been challenged based upon constitutionality, based upon the classification of race or nationality, have always been deemed to be unconstitutional. It's just because strict scrutiny is such a high hurdle to jump for that law that not many laws have been able to, as they're written, have been able to jump that hurdle. Korematsu was the only one, and like I said, it was it was good law. It is what it is. So they applied strict scrutiny test, and they found that it was constitutional. Once again, the burden of proving that the law is constitutional rests upon the proponent or the lawmaker. So that is equal protection. Now, I know we've gone over an hour. I'm going to go a little bit longer to finish out the chapter, but that's very important. So I'm going to actually I'm going to give you my detailed outline that I teach from. I'm going to give you guys a copy as a supplement. I'm also going to include not just this lecture, but there are going to be supplemental lectures from other professors on YouTube to kind of help get this equal protection analysis in your mind, because you're gonna need this in this class this semester. Now let's quickly talk about freedom of speech, and we'll blast through this. The First Amendment: Congress shall make no law abridging the freedom of speech or of the press, or the right for people to peaceably assemble and to petition the government for redress of grievances. The First Amendment is applied to state laws by way of the Due Process Clause of the First Amendment. So the 14th Amendment essentially, the due process clause of the 14th Amendment, I'm sorry. So the 14th Amendment was one that what kind of, because before when you had the Bill of Rights that essentially just applied to the federal government. The 14th Amendment says no, it brought it all in and said this also applies to the states. So the due process clause also incorporates various fundamental freedoms that generally correspond to the provisions of the Bill of Rights, first 10 amendments that create rights against the federal government. And this is what we call the incorporation theory. So that means the 14th Amendment, by theory of incorporation, it incorporates the first 10 amendments and applies them to the states. So, 4 functions central to democracy performed by freedom of expression. So without the First Amendment, we wouldn't have individual self-fulfillment. And that's encouraging individuals to express their ideas and creativity. It's the one thing about America, because we have freedom of speech. That's one thing outside of the fact that slavery advanced us economically, because we were able to catapult ourselves economically without paying like a whole race of people for the work in building the country. But also having freedom of speech, it opened the marketplace of ideas, and that's what kind of allowed us to be a technologically advanced country, because people aren't held back educationally or academically or in saying what they want to say. It created a vigorous marketplace of ideas, a diversity of views, and expressed and considered in reaching decisions. It also creates the promotion of social stability by providing individuals the opportunity to be heard and to influence the political and policymaking process. This promotes the acceptance of decisions and discourages a resort to violence or staging a coup and overturning the government. It also gives the government the ability to identify and address newly arising issues. The steady stream of innovative ideas will give the government what we call constructive insight, what we need to change. So the balance between liberty and social order. So when we talk about the First Amendment, we're always talking about the balance between me doing what I want to do and me having liberty, and also having to maintain social order and making sure we having some, limits and rules. There must be some limit to freedom of speech to ensure social order. We must always weigh the benefit of the expression versus the interests of social order and welfare. So there's the benefit of what's being said in this First Amendment, in this freedom of speech, and this speech or this expression versus. So in other words, does the expression have any type of benefit to society? That's what and then we're weighing that benefit versus the interest in keeping social order. So those are the two things we weigh in when we analyze the First Amendment and any law that kind of abridges or your ability to speak freely. Because we're weighing that the benefit of expression versus the interest in social order, we have some expression that's not protected, or if it is protected, it's protected way less by the First Amendment. Expression or content, or when we say expression, that's the speech, or and it's not just speech. What comes out of your mouth, it's art, things you write, things like that. So instead of saying speech, it makes it sound like it's just what you say. We substitute the word expression. Expression is not protected by the First Amendment. These utterances are not an essential part of any exposition of ideas, and are of such slight social value as to step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. So like I said, we're always weighing the value of the expression, like does it hold a value to society, does it help us, versus order. So the things that are going to be less protected generally don't have a very high value to society. So that means that the order, the social order aspect is going to outweigh it because it doesn't have value. So in other words, for something to really be protected to the utmost by the First Amendment, it has to have some type of societal value. So some of these things that are not protected, we have fighting words. So you're allowed to say fighting words, but they're less protected, meaning they're going to be fighting protection is going to be subject to more what do you call it? Government intrusion and government regulation. So these are words directed to another individual or individuals that an ordinary and reasonable person should be aware are likely to cause a fight or breach of violence. So you're allowed to say what you want to say, but depending on the circumstance, you're going your speech or your expression is going to be regulated if it tends to be something that something that could cause a fight or a riot. And once again, then we're going to move on to incitement of illegal, violent action or a riot. When there's clear and present danger of a riot, disorder, or interference with traffic upon the public streets or other immediate threat to public safety, peace, or order appears, the power of the state to prevent or punish it is obvious. So you're really not protected in causing a riot. So there's zero protection in causing a riot. There's a little bit of protection in fighting words, but it's going to be subject to government regulation. So it's really not really protected, and there's no protection at all for inciting a riot. And so it's not just inciting a riot or illegal action. Then there's also no protection in a threat. So you can't. So in other words, we have the First Amendment, but you can't just say what you want. You can't spew fighting words. You can't incite a riot, and you can't threaten people. Law prohibits threats of bodily harm directed at individuals. Factors for determining threat, including the ability to carry out the threat and whether one is placed in apprehension of such a threat. Exaggeration is different than a threat. Exaggeration is distinguished from the threat because it does not meet the requirements of a true threat. This also depends on the response of the listeners or a person being threatened. In Watts v. United States, which is the case, the defendant's statement that if he were in the army, he would use his gun to kill the president was laughed at by onlookers. The Supreme Court overturned his conviction as saying that it was an exaggeration and not a threat. And it's definitely not a threat if it's conditional. So if there's an if in the threat, like in other words, if you pull out that gun, I'm gonna kill you. That's not a threat because there is a condition on it. Or if you come over here bothering us, I'm gonna kill you. That means you have to take an action in order for me to now, come through on that promise or that threat. So exaggerations and conditional promises or conditional threats don't necessarily classify as threats. Then the last but not least, then we have obscenity, and this is when we talk about pornography. Pornography is protected, but it's highly regulated, meaning it's less protected, and that's because there's, like I said, we're always weighing the value to society over versus social order, and with obscenity, there's very little value to society. Obscenity is works that, when taken as a whole, in light of the contemporary community standards, appeal to the prurient or sexual interest, and they are patently offensive, and they lack serious literary, artistic, political, or scientific value. So pornography. Then it depends on the type of pornography. Child pornography there's no protection whatsoever. It is illegal. With adult regular pornography, it is protected, but it's highly regulated. So pornography is not illegal, but you can only have access to it or have it if you're a certain age. So 18 years or older, you can only partake in pornography if you're over the age of majority. So it is highly regulated. So that's why there's Pornhub out here. Pornhub is not illegal. Now, having child pornography is illegal. There's no protection at all. That is illegal. So it's not even a matter of it being regulated. It's not even regulated. It's illegal on its face. But regular pornography, logging into Pornhub, that is not illegal. But it is regulated. You got to be 18 years or older. And to even partake in pornography in the industry, you got to be 18 years or older. So it's highly regulated. So there are regulations and the standards, and there are things they have to do in order to even be a part of the pornographic industry. Then you have the last but not least. Yeah, I did have one more. You have libel and slander. Civil law enables individuals to recover damages for injury to their reputations based upon what somebody says about them is not true. Public officials and celebrities must prove that there's actual malice to get any type of civil redress for libel. So when we talk about libel, we're talking about slander and defamation. So you can say bad things about a person, and it can be lies, but you may suffer the consequence of being sued. Now, it doesn't mean that you're going to be held criminally responsible or arrested because you said something bad about a person, but there's less First Amendment protection because that person can sue you for what you said to a third party. So those are just the types of speech that either are not protected by the First Amendment or are protected, but they're highly regulated, meaning they're less protected. So, common characteristics of speech lacking First Amendment protection. The one thing they all have in common is they lack social value, and sometimes they directly cause social harm or injury. They're narrowly defined to avoid discouraging and deterring individuals from engaging in free and open debate. Now we're going to talk about overbreath. So we talked about vague, and now we're going to talk about overbreath. A statute that is overbreath is unconstitutional, and because it's so broadly and imprecisely drafted that it encompasses and prohibits a substantial amount of protected speech related to the coverage of the statute. Badly drafted statutes aren't considered overbreath when their legitimate reach dwarfs its arguably impermissible applications. Now we're going to move to hate speech. Speech that denigrates, humiliates, and attacks individuals on account of race, religion, ethnicity, gender, sexual preference, or other characteristics and preferences. This is distinguished from hate crime. So a hate crime is an action that's taken an assault or damage to property or something like that, and they're deemed hate crimes because they're done with a racist or a specific malicious intent, racism. So these are penal offenses that are directed against an individual who is a member of a protected group. Benefits of hate speech. So hate speech is different from a hate crime. So you're allowed to say the N-word and hate people and say it. As long as it's not a fighting word or say it in a situation where it's likely to cause a reaction and start a riot or a fight, then it's not protected. But if you're just saying it because you're saying it and it's not said in a certain situation, like if you got a podcast where you want to say what you want to say about black people, you're well within your right to do that, and that is protected by the First Amendment. The benefits of hate speech. Society benefits when views are forced out of the shadows and compete in the sunlight of public debate. So it actually is a benefit to knowing that someone is ignorant enough to hate me because of my race. At least I know who they are. I don't have to guess. Then we moved on from hate speech. So hate speech is protected. Then we have the expression of actions prohibited by the First Amendment. Conduct may be protected under the First Amendment where there is an intent to convey a particularized message, and there is a strong likelihood that this message will be understood by observers. In these instances in which an act contains both communicative and non-communicative elements, the standard is judging the constitutionality of the government regulation of what we call symbolic speech. What we're doing now when we Black Lives Matter marching, that is symbolic speech. It has a lot of symbolism. You have people marching with tape over their mouths, wearing shirts. It's not bothering anybody. As a matter of fact, you get a permit, you do it, and even if you don't get a permit, sometimes blocking the street, that's the whole point of protest. Protest is meant to, especially nonviolent protest. Nonviolent protest is meant to essentially be inconvenient. So sometimes the only time people can hear what you're saying is when they're inconvenienced. So blocking I-40 like they did back in March, April and March, that kept a lot of people from getting where they were trying to go, but they heard Black Lives Matter. Like, hey, we're trying to say something. Stop what you're doing and listen. So it's necessary. but it doesn't mean they don't get arrested for blocking traffic. But that you have to break laws. Sometimes you change laws. So Martin Luther King is an example of that, and the Honorable John Lewis, who recently passed away. That's how they protested: nonviolent protest that caused inconvenience to make people listen to what they had to say. Okay, now we're going to move on to privacy. Privacy, although privacy was not implicitly mentioned in the Constitution, it was not explicitly mentioned in the Constitution. It was implicitly incorporated into the text. This right was created by several fundamental constitutional guarantees. These rights create a zone or penumbra of privacy. The Third Amendment prohibition against quartering soldiers in any house without the consent of an owner. So in other words, that protects the sanctity of my house. You can't just come in my crib and because you're a soldier saying we're going to commandeer your house and use it. No, this is my house and I have privacy here. Then you have the Fourth Amendment, which protects the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures without warrant. Then you have the Fifth Amendment, which now affects what I can say and my ability to remain silent. Incrimination clause, the Fifth Amendment incrimination clause enables one to create a zone of privacy that the government may not force him to surrender or say anything to his or her detriment. Then you have the Ninth Amendment. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So it's like the catch-all. Ninth Amendment is like the catch-all. We are free to make day-to-day decisions that define our unique personality. What we eat, drink, and watch. Where we live and how we spend our time, dress, and act. And with whom we associate and work. The core concerns of the right to privacy. The sanctity of the home. We all, so even in future chapters when we talk about crimes against the home and property, it's all about sanctity of the home. Freedom from arbitrary government intrusion. You have intimate activities, freedom to make choices concerning a personal lifestyle and an individual's body and reproduction. There were actually cases that were deemed to be unconstitutional that made essentially homosexual sex illegal. And it's like that was an invasion of privacy. And of course, we applied, because of sexuality, a law that classified based upon sexuality. We applied intermediate scrutiny. Intermediate scrutiny was applied to those cases, and they were deemed to be those statutes, and they were deemed to be unconstitutional. Because for you to know what type of sex that a homosexual is having, you have to be in their bedroom, and that is where they are. That is privacy. So you can't. So in other words, the only way to determine that they are having sexual relations of any kind is you have to now be in their bedroom where they're within the penumbra of their privacy. So that in and of itself, based upon two reasons, not just the fact that they're classified and that it was not a important government interest, but also because in order to enforce that law, you would have to violate privacy. So then you have information. The right to prevent the collection and disclosure of intimate or incriminating information to private industry, the public, and government authorities. Then you have public portrayal. The right to prevent your picture or endorsement from being used in an advertisement without permission, or to prevent the details of your life from being falsely portrayed in the media. Right to privacy examples and cases. You have Eisenstadt v. Baird. That's the right of an individual, married or single, to be free from unwarranted government intrusion into matters so fundamentally affecting a person as a decision of whether or not to have a child. Then you have Roe v. Wade, which was, that's the right for a woman to make choices in her body. That is a privacy right. Women's decision whether or not to terminate her pregnancy. Essentially, it's based upon her body and what she wants to do with her body. Then you have Lawrence v. Texas, and that's the case I was talking about, where same-sex sexual relations between consenting adults were prohibited by Texas state law, but that law was deemed unconstitutional because, for one, it was not an important government interest that was being furthered, and two, it was an invasion of their privacy. So for you to even know what type of sex, anybody's having, you have to invade their privacy to do so. The reasonable expectation of privacy. And you'll hear this especially when we talk about, we're not going to talk about that in this class, but in criminal procedure, when we talk about Fourth Amendment and what the Fourth Amendment protects when it comes to what law enforcement does and what they search and what they can search and seize and get a warrant for, we talk about something called the reasonable expectation of privacy. It is a place where a reasonable person will believe that he or she could disrobe in privacy without being concerned that his or her undressing was being filmed by another, or as a place where one may reasonably expect to be safe from casual or hostile intrusion or surveillance, including the bedroom, the home itself, the bedroom, bathroom, dressing room, or tanning salon. So this also includes areas in the public. So when you're in a dressing room getting undressed in a public shopping mall, that is within the penumbra of a reasonable expectation of privacy because you're disrobing. Also, rooms in an individual's home where someone would not normally disrobe, but would not expect others to intrude, such as a private suite or office. So your home is always within that penumbra of the reasonable expectation of privacy. So that is the close of Chapter 2, the constitutional limitations. So I talked about laws, the way they're written, and determining the constitutionality of laws. So are they written well? Or, of course, we can't have bills of attainder, ex post facto laws. Then laws can't be overbreadth or vague. So we need to know, there's a rule of illegality. So we need to know what's legal and what is not legal, and it can't, you can't punish me for something that's not illegal. And then two, we talked about the equal protection of laws. If we're going to make laws that differentiate people or treat people differently, then those laws are subject to the equal protection analysis to determine whether or not they're constitutional. Then after that, we start talking about your First Amendment rights, because of course you're right. You can be arrested for First Amendment expression, and the question is, did you have a right to express and do what you did? So when we watch these protesters getting arrested, are they within their rights? Now, once you get violent and it becomes a riot, then of course you've incited a riot and it's no longer a protest. It is now a riot. So just marching down the street and saying what you have to say, you're protected. But then when you start breaking out windows and property damage, you're not so protected. Now, that's not my opinion. That's just what it is. My opinion is that, the United States of America was created based upon rioting and violence. We were created based upon a war. So that means a lot of times for stuff to change, things have to get hurt, things have to get burned down for things to go in the right direction. But that's just my opinion. That's not in the book. So that was the close of Chapter 2. I told you I'm going to post my outline, what I teach from, so you can read it yourself to help you, supplement you. And I'm going to also post 2 other lectures to assist you as well. So without further ado, take care, enjoy yourself, and read the book.